program, which is a new accelerator. We're basically teaching 30 faculty student teams annually the commercialization process, and we actually just closed the applications for the summer cohort, but we'll be doing this in the fall. And if you're interested, please contact us. I think it's a great experience for anyone interested in commercializing early stage technology here at Penn. We're also doing an event we're excited about next Tuesday at the Science Center as part of Philly Tech Week, where we're going to be highlighting early stage technology, mainly from the engineering and School of Arts and Sciences. So if you're interested in some of that, it would be relevant to some of your work next Tuesday at 4:30. So now I'm really pleased to introduce our speakers. Today we have actually, who will be speaking second, as a reminder of kind of what the role of PCI here is at the university in terms of commercialization and patenting, is my colleague Jen Langenberger, who's the Director of Intellectual Property. But first, I'm really pleased to introduce Ram Shukla, who joins us from the US Patent and Trademark Office. He's been there 16 years, brings a lot of experience in the process, and specifically has a focus on cellular immunology and the use of antibodies in diagnosing and treating disease. I know he has, over the years, read a number of Penn patents, and I think Penn has a reputation as being very active among universities in producing patents, and so I'm really pleased to bring him up to give a great overview about the Patent Office and their approach. Well, and one last thing I should highlight, which I generally do before the intro session, is we're going to have presentations and then definitely open it up for questions. Also, there's a number of PCI staff here who are experts on working with faculty on patenting issues. In particular, I wanted to highlight Vivian Martin, who's the director of our office here at the medical school, and her team, and she is really your key point of contact for moving any of these issues forward. Ron.
Okay, thank you, Lauren. I'm quite loud, so I guess with the help of this, I should be able to reach in the back. And thank you for inviting us. As Lauren said, I have been at USPTO for actually over 16 years now, and last 10 years I have been a supervisory patent examiner. I have been in different areas. Currently I'm in the antibodies therapy. But before that I was in nucleic acid diagnostics, and also as examiner I examine in gene therapy, transgenic animals, vectors area. So I've been in the related areas, all along. So what we are going to do today is give you an overview of IP, and I'm sure most of you are aware of IP, so it will be quick. And then patents, and especially the patent process. When you apply for a patent, or when your application comes in, what it goes through, how the process goes. That's what I think my focus, I will try to focus on. We'll also have some slides and tools and resources. We have a lot of resources as an inventor for you, even if you want to know about the process, and the new programs which we have started the office at the start, so some about that. And then I will be touching the recent changes in patent law. So what is an IP? This slide kind of puts different types of IP together in one, and the first one is here is a utility patent. As the name indicates, a patent which has a utility or a use. Basically, that would be in a very simple term. And you have examples for iPhone, iPod, of course, but in biotech area, you can think of vaccines, you can think of vectors, transgenic, bacteria, and so on. So those would be some in the biotech area. So the protection is for 20 years from the date of filing, and I'm sure you have experience if you have filed that there is a pendency, and sometimes if there is a correction, there is a patent term adjustment for that, when an application is allowed. Design patent, so that is for ornamental part of an object, so that's what it would be. The term for that is 15 years, again from the date of filing, and it gets implemented in May. Before that, it was 14 years. Copyright, and again, I think that's one thing, IP which we don't realize that we have, but immediately as you write a paper, write something, put something on a media, you have a copyright. You may not have registered it, but you do have. And then the term for that here, as it says, is the life of the author for 70 years, and some situation 95 years from first publication. Then we have trade secret, and as the name indicates, it's a secret. So for example, a formula you have, Coca-Cola is an example, where you keep it secret, and then you have that protection as long as you can keep it secret. And then finally, trademark. And trademark is more words, symbols, logos, designs that would be, they are covered by trademark. And idea being that you will identify a product you see, you will know with that logo, with that design, what that is, where it is from. And the example here is the iPhone, and so the one product can have different types of IP in there, not just a patent, not just a trademark, but multiple. For example, for iPhone here, right? Trademarks made by Apple, that's the logo. You have the product, then you also have the softwares, iOS, Safari, that would have. In terms of patent, different parts of the semiconductor circuits, chip, speaker, all those are protected by patent, utility patent. And then we have our design patent, and copyrights, software code, instruction manual, trade secret. Well, we don't know what the trade secrets in there. If that's a secret, that's the whole point. And then of course, design. So just to give you an overview of the office, we have over 8,600 examiners, patent examiners, who examine technically, but not technically, really, every technology in this universe which comes to us. We have to find an examiner to examine that. So we examine everything we get. 618,000 patent applications have been filed. Last year, again, these are numbers from 2014, we issued 329,000 plus patents, and then we have trademark attorneys who examine trademark applications, and then we were getting around 336,000 applications in that area, and then 206,000 plus they were registered. So when I started 15 years ago, there were about 2,400 examiners, and now we have 8,600 examiners. So we have really exploded, but at the same time, we have a lot of applications. And our pendency, as you will see in the later slide, we still have, depending upon what the technology area is. So the office is divided into different, for the purpose of administration. And the patent examining code is under the Deputy Commissioner for Patent Operations. And like I said, there we examine every possible technology. So to manage that, the code is divided into 9 different centers based on what technology they are examining. And then each technology center will be divided into smaller groups called work groups. So nucleic acid work group, protein work group, peptide work group, and then pharmaceutical work group. And then work groups are further divided into art units, where you will have very specific area being examined. So examiners will have the expertise in that area. They will have the docket of applications in that area. So what is a patent? Again, so it's a property right, and for any property, that's what you have a right. In this case, to exclude others from making, using, selling, offering for sale, or importing the claimed invention. You have a limited term. That's, we said, 20 years from the date of filing, and then it's territorial. That's the most important thing I will say. Would be just to think of that if you get a patent in U.S., that doesn't mean you have protection in any other country. So you have to think as an inventor, as a business, what your future plans are, and accordingly protect. So government grants the property right in exchange for the disclosure of the invention, and that's what this patent is about, right? You disclose it, and the system is that you are disclosing your invention, and in return you are getting this exclusion. So what does the patent system really do? Protects inventions, of course, that it does. Then it encourages, because once your patent is out, somebody will take that and they may add to it, improve it, so they will encourage further innovations. Promote commercialization and application of invention. So you license it, you create a product, diagnostic kit. All those things, they are adding to commerce. They are producing jobs and so on. And then accelerate the commercialization of invention to the whole society. That's again the part of the process. So types of patents we mentioned earlier are that there are utility and design, but we also have plant patents. So to start with the utility, and I have used a patent in here, one from UPenn, and I believe this is the one I used for even using a claim, just to talk about it. So it's a utility patent which you get for a new and useful process, machine, article of manufacture, or composition of matter, or any new and useful improvements thereon. Okay. And then you are disclosing how that invention works, basically, so that you are able to, somebody who looks at your patent, they are able to practice. They can do it. That's how to make and use this. So design or ornamental design, and then plants. So you can get. Back. Okay, so you can also get a plant patent. Now you can also get a utility patent on a plant if it is a transgenic plant, for example, or so the plant patent is for asexually produced plant. So this is the difference from the utility patent. So you can get a utility patent also on a plant. Okay, so there are two types of it. Now we will focus on the utility patent. And so there are two types of applications. One is provisional, the other is non-provisional. As you will see here, provisional, it has a 1 year, basically 1 year period, and cannot be extended. There is no extension in here. It's a placeholder, basically, and for you to decide what you want to do next. And then you are not required claims in there, but description has to be, but think about this way, that if you are going to file a non-provisional of a provisional seeking priority, what you have disclosed in the provisional. And if you add things to your non-provisional, then of course things change, because if something was not disclosed in the provisional, you may not get priority to that subject matter which you added in your non-provisional. So think about it when you are filing a non-provisional. It's not just a placeholder, but you got to have the description, which is which you want to take into non-provisional. So without going into strategy and all that, think about that, because if you're adding something new, you may not be getting the same priority date. Non-provisional, so as I said, that's the one which will end into a patent. Provisional application does not get you a patent. Okay. And you need a claim in there, because that's what really defines your patent. So what are the parts of a patent application, a utility patent application? Title and abstract, of course, they're needed. Drawings. If you need drawings to explain, yes, have the drawings. In biotech, it depends what you want to have. Maybe you may have a vector. You may have any other. You did experiments, you got results. You want to show those in the drawings. You may want to put there, but drawings are part of the description. Okay, so that's and it will help you. It may help you, if the need be, to define, to disclose your inventions. Background of the invention, brief summary of the invention, brief description of the drawings. If you have drawings, then you have to describe what those drawings mean. Results, or whatever you have in there, and then detailed description. Because remember, this is you're disclosing so that somebody will be able to use it. And claims. So claims are the one which define what your invention is. It's like thinking about your property and surveying as to where the fence is. That's what your property is. And during the processes, we will go, we will take a look at it as the examination goes through. That's what you work with the examiner, and to see where that fence, that property is. So just some numbers. Right now, average pendency is about 28.6 months as of January of this year. Now that depends on what technology it is in, and with the new law change, there are now different fee structures. You can get, you can pay less if you meet requirements to be small entity or micro entity. And then there is a maintenance fee for the patent once it is granted. Then a different time period, you have to pay maintenance fee. Now the fees change, so you have to, when you have to go and check what the current fee is. Now going for the application process. So when you file an application, what really happens, it comes to the office. It will be sent to one group. It's called initial examination. The name, in fact, has changed. We keep changing the names of the offices. But what they do is they check for the formalities, that you meet all the requirements. For example, for biotech, nucleic acid sequence information is one thing. If you don't have sequence description in there, that could be a problem. You will get a notice back that you haven't supplied the nucleic acid or protein sequence listing. Once that is done and it's complete, then it would be it's classified and for assignment to examiners. And based on the classification, it will go to the examiner who examines in that classification area. Okay. Examiner goes through the process, and once it is decided it is patentable, then it will go to the next division. It's called post-examination, where it will be published. So post-examination part of the office, they also publish the patent applications, what is called a pre-grant publication, PG-PUB. So as you may be aware of, after 18 months, every application is now published unless you come and tell us you don't want it published, or it is a classified or some other reason why it cannot be. So what the process in general looks like is really the examiner between you and the applicant, right? So examiner will go and look at your invention, it will analyze it, and then they will send you correspondence to you. You look at that correspondence, we call office action, and then you want to rebut it, you agree, you don't agree with it. If you agree, it may, okay, fine, there's not, it goes to abandonment, you may change the claim. So you go back and forth. The process is, once it is decided, examiner makes a final rejection, you either go and appeal to the next level, or you decide, okay, it's not worth, I'm going to just abandon it. Or maybe examiner, is now after, rounds of discussion or back and forth, that you have got an allowance, you have got a patent. So those are the three outcomes. You get a patent, you abandon it, or you go to the next level if you think that, no, you should get a patent, examiner is not right. Okay. So what the examiners do, they will really look at your application, go through it, analyze and decide whether it meets the requirements, and what the requirements are will come next. And as the law says that an applicant is entitled to a patent unless examiner can show that no, it's not patentable. So initial burden is on the examiner. We talked about it again, the same. Move on. Now this slide kind of shows the process internally, that their examiners are given multiple tools to prepare the office action, search, and then communicate with you just to make the process efficient. The goal of different, for example, the second one, the bit number 2 is the most important part, which is searching. So examiners have access to any document technically available anywhere in the world in different way. And if it is available, they try to find it, they find it, they will bring that and apply so that you have a quality patent. That's the goal. So what are we looking for, right? When we are analyzing, there are different statutory requirements, and one is 101. Usually patents are provided for a new, non-obvious, and useful. Okay. What those are, what the subject matter should be: process, machine, article of manufacture, composition of matter, and improvement of any of the above. Now this has got 2 requirements basically. It is a utility patent, right? So everything should have use. That's the utility part of 101. The second part is subject matter eligibility, as you may have seen, or you may have realized in your own applications, that sometimes things are not patentable because they are product of nature, they have abstract ideas, and that could make it unpatentable. So that's the second part of 101. Now there were changes, recent changes in last 1 year, I will say, with new court decisions, Myriad, and then we have Alice and different court decisions, which have changed what is patent eligible subject matter, what is not. So we do have on our website for the guidelines, which we recently created, and it was updated back in December. So I would say go and look at it, and you will be, it does give you examples of what, and again, for biotech specific examples are there. Okay, so what are the other requirements for the patent? And it should be novel and new. That's what that means. Non-obvious. Novel means nobody has done it exactly same what you have got and described. Non-obvious means that if you are in that field and you are given all the information available to you, can you really make that invention? in very simple general term, is it obvious to do? Okay. So that's what non-obvious is. Then have you described it adequately or enabled? And enablement and description, that's something you will see more in biotech area, don't see in engineering, others, because of the state of the art. A lot of times you may think, you give a claim, it's very broad, it's what we call genus, and you may not have description for the entire genus. So that's, written description. What is, again, deciding what is where your property rights are, where the fence is. Because you may think you have the universe, but you may just have a house in Philadelphia. I mean, that's how we take it. That's how it is analyzed. Okay. And then enabled means how to make and use. That's the test. That can use. So if you say treating a disease using peptide X, well, a disease could be any disease. If that's what you are claiming, can you really treat any disease? And what examiner will do, they will look at what is available there, and based on the state of the art, can it be done? That's enablement. Examiner is going to look at that. So I already talked about these two slides. Written description is, have you described making and using it? And then the second part of this is important when you are working again on the claims, is that the specifications shall conclude with one or more claims, particularly pointing out and distinctly claiming. So meets and bounds where your invention lies. Is it clear, not clear? Because when somebody looks at that claim, they should be able to see what is your invention. So that's 112B. Okay. Non-obvious, that's what the statute says. I already talked about that. Now this is a claim I took from that patent. And as you can see, so it's a method of inducing immune response, and then and again you see that there is a seq ID number in there with the specific residue numbers, base pairs in there. Now, and that's what I was talking about with respect to how broad it is it enabled or not? And if you go back and I'm sure, well, I don't know, if the application was published, you can see how the claim developed over the time from when it was filed to what was issued, based on going through the examination process. Okay, so that was the examination process. I guess in the interest of time, I'm trying to, go fast. We can have. So Office has got a lot of resources which are available to everyone, and one of them is MPEP. This is what we call as the Bible, and in fact, the co-speaker, she works there. You get everything in MPEP. That's what examiners follow when they are examining their applications. We have got a lot of initiatives to help you because we have pendency. We have like 28 months, as one of the slides said. So if you're in technology, you want to go further, faster, then we have got different initiatives at different stages of the application. So first step, first action, during prosecution, or even at the final rejection time, there are different initiatives you can take advantage of. So one of them is track 1, where you pay extra and you can move your application the front of the line. Basically, within a year, you will get a decision on your application. But there are limitations. You can only have certain number of claims. The other one is first action interview pilot, where before examiner sends you any action, you can have an interview. There's a process for that. Now, a lot of times examiner is working with the applicant, attorney, and they cannot, reach to conclusion. There is disagreement. There is a resource available of ombudsman program who would be, glad to help you. Now, this is a tool which I have pride in saying. I developed this. I was away from examination for a year. Very simple, and it's good for students, postdocs, professors, where you can learn about IP in general, and not just the patents or trademarks, but even international licensing and all that. General information, go through the awareness of testing. It's not really a test assessment. You will be given then the response with links and information which you can go and read to further increase your awareness. And then we have information on litigation. Again, the office is working on several White House initiatives, and this is one of them, part of that. And I want to mention, I don't have a slide on that, another program is called Patent Examiner Technical Training Program, where we invite you researchers, scientists, inventors to give presentations, seminars to examiners. You can come to PTO and give that presentation, or you could do through WebEx, one of the services we use, and online, and you can just present from your office to the examiners. And it helps. Now, the only caveat of the problem is that the office doesn't pay for any of these, so you are just volunteering to give free service to the office to help examiners increase their technology background, basically. But I'll be reaching out later on. I'm the person of contact for our technology center to use. If somebody is interested, that would be a great thing to do. So we have moved on. We used to have our own classification system. Now we have going on a CPC, which is for the started with EPO, but now with more countries, and we'll have on a broader scale. Idea at some point being a world patent whenever that happens. And then we had this patent law treaty. There were some changes, important changes about plant patents. And also when you can revive your application, that's actually much more, that has impacted people. How you can revive, let's say it went abandoned, you didn't know about it, or whatever happened, and you can revive it. So these are some other resources. A lot of resources are there on our website. Please do visit USPTO.gov. And with that, thank you. And any questions? Or you want to talk to President?
Why don't we have Jen, why don't you go up, and then we'll take questions at the end as opposed to everyone. I also just wanted to highlight this presentation. We will have a link to on PCI's website, which is pci.upenn.edu. So it's meant as an ongoing resource for you. And I'd like to again introduce Jen Langenberger, who she's going to quickly talk through the process for if you're a faculty member or a student who's working via a research project at Penn using significant Penn resources, and you have a discovery, you're, through our patent policy, obligated to disclose to our office, and we work with you to facilitate the patent process. And so that is what Jen is going to talk through quickly.
Yeah, I'm just going to take a quick 5 minutes to sort of run through why you would bother with us and how you would work with our office. So sort of the 50,000 foot view on how we work, and then we can take questions. I think that's valuable. So why are patents important to translational research? Basically, we do a lot of bench research. It's funded by the government. Sometimes, more often, it's funded by companies. And patents are a tool that we can use to attract investment in that research. Because companies, their primary goal is to make money, and patents, it's important to remember in the back of your head somewhere that the patent and trademark system is under the Department of Commerce. The purpose of a patent is a revenue generating tool. And so when we, the university, file on patents, it's in hope that we can attract someone to invest in research, someone to continue to help bring a product that we've researched, but maybe we don't have the tools necessary to handle manufacture or getting through the FDA, like a corporate partner that can really help us make this, advance it. So the patent grants them, as my colleague mentioned, a monopoly for up to 20 years, and that's why they might want to do so. So when we do our patent filing analysis, when someone sends us an invention disclosure, there are two key things that we look at. One is obvious, which is, could we get a patent on this? Is this eligible subject matter? Is there prior art that is around there? Is the application enabled, or have they only done it in cells and they're wanting to treat humans and there's just too much work to be done in the meantime? The other thing that our office needs to look at that sometimes people don't necessarily think about is, what are the other patents out there? Are they going to keep us from practicing our invention? And an example of that is, you discover that a drug that's already known is useful to treat a new disease that it's never been known to treat before. And that is a patentable invention. But it's also an invention that somebody else, the drug itself may have been patented by someone else. So in order to practice your new method of treating, say, heart disease with this drug, you would need to go to the owner of the patent of the drug itself in order to practice your invention. And so that's just part of the analysis that we do, because when you look at a commercial opportunity, you want to make sure not only that your patent's going to be valuable for excluding others, but also that you're going to be able to, what you're going to need to do to be able to grant others the right to practice it as well. Okay? So the process, working with PCI, you fill out an invention disclosure. We have a new inventor portal, and you can fill out your disclosure through the inventor portal, or you can use the traditional email to fill out our form and fill it out online. We have a fellows program. They review prior art. Sometimes they take a look at the market. Our licensing group, and those are people who typically have an advanced degree in science as well as experience in business and law. So they're sort of a jack of all trades with a lot of experience in business and negotiations. They can understand your science. They can also understand the legal landscape and where it's all going to fit in. They're going to make a recommendation. Should we file on this application? Try for patent protection. Is another form of IP suitable? Like, sometimes inventions just aren't suitable for patenting, but they're still commercializable. Sometimes software, we license a lot of animals, transgenic animals outside of the patent process, and they can be very profitable without having to file a patent. Sometimes you've done some really early stage research, you're not about to publish it, and we'd rather hold off on filing patents, so we'll put it on hold. Or sometimes it's a great science, but it's just not a great commercial opportunity for reasons I've mentioned, reasons that were mentioned here, or reasons that there's a lot of them. So we would work with you on determining that. Once the patent is filed, the inventor, our office, and our patent counsel, we always work with outside counsel, we'll work with you on what the invention is, what the claims look like, and we'll draft an application. We typically would file a provisional application first, as mentioned, but then our next step would be to file an international application, which basically, although it delays examination in the U.S. slightly, it reserves our right to file abroad if we've attracted a company that's interested in doing so as a licensee. The invention will be marketed by a licensing person. If someone reaches out to you at a meeting and says, that's interesting, put them in touch with your licensing person. It's an opportunity for us, once we have the patent filed, to try to generate interest in the invention. We would either negotiate a license, or it could possibly go to a startup company. There's other models as well, but that's all things that our TLO group and our ventures group are well versed in, and they can absolutely help you with. And then just the patent policy, which I'd like to touch on just really quickly. Basically,